Obviously, if you purchase this program, you're considering filing bankruptcy. Well, my goal is that by the end of this program, you will have a very strong familiarity with the bankruptcy process and you will be better informed with regard to your decision to file. Please keep in mind that this program is not designed to be a substitute for the advice of a skilled attorney in your area. This information is to better educate you with regard to what to expect in the typical bankruptcy case and to better prepare you for your meeting with your attorney. However, this is not legal advice, and I do not recommend you file bankruptcy without the assistance of a lawyer. Okay. Well, now that I'm done with all the legal disclosures that my lawyers told me I must include, let's get down to business.
The following is an explanation of the two basic types of bankruptcies, the Chapter 7 and the Chapter 13, and what is required. Don't hesitate to review this presentation many times, as this information will be very helpful to you.
Chapter 7 bankruptcy is the liquidation of all your debts without the necessity of having to make payments on a monthly basis.
Your case is filed and completed in approximately 90 days. Chapter 7 is filed when there is no money left over at the end of the month to pay your credit cards and other bills. You may file for Chapter 7 bankruptcy every 8 years, and it's measured from the date of the earlier bankruptcy filing. So if you filed on August 1st of 2000, you will not be able to file again until August 2nd of 2008. Under the Bankruptcy Reform and Consumer Protection Act of 2005, what we're going to simply refer to as the new law, you must pass the means test in order to qualify for a Chapter 7 bankruptcy.
What this means is that your monthly income must be below the median income for your state. The median income for your state is the amount that is sort of middle of the road.
Income for a family of your size, whether it's just you or you and a spouse. We've provided you with the median incomes for each state in your materials, and they are accurate as the date of the production of this program. Your income is determined by calculating your income for the 6 months prior to the filing of your bankruptcy. It doesn't matter if you're currently making that amount.
So if you're unemployed at the time of your bankruptcy filing, but had employment for the 6 months immediately before, your income will not be zero. It will be the average of the prior 6 months. Your income includes regular income from all sources, except Social Security, which is not counted in your budget. Please fill out the income sheet provided with your materials.
Once you've calculated the average of your monthly net income after taxes and deductions for the 6 months prior to filing, you must compare this to your state's median income. If your income is greater than the state's median income, you fail the means test and you will likely be required to file a Chapter 13 payment plan, which we will discuss further in a few moments. Now, if your income is less than the state's median income for your family size, you pass the means test and you're able to file for the Chapter 7 wipeout. The Chapter 13 bankruptcy means you will make payments on a monthly basis for up to 60 months to a case administrator known as a trustee. This is the bankruptcy you file when either you don't qualify for the Chapter 7 wipeout or you have priority debts like money owed to the IRS or child support that can't be eliminated under Chapter 7.
This has been an overview of how the trustee will determine whether you get to wipe out your debt under Chapter 7 or whether you're in it for the long haul in a 5-year Chapter 13 case. Your attorney may advise you to do Chapter 13 if you have IRS taxes, child support, or alimony arrearages, or other non-dischargeable debt. What do the bankruptcy papers look like? There's the petition itself, the schedules, the statement of financial affairs, the statement of intentions, and the attorney statement.
The petition itself is a pretty short document that just gives the debtor's name, address, approximate number of creditors, and approximate total amount of debt owed. It gives how long you have lived in the jurisdiction and whether you have filed for bankruptcy in the past. The schedules go from A to J as follows.
Schedule A consists of real property that you have an interest in, such as your home, raw land, etc. Schedule B consists of basically all other property you have aside from your real property. It also includes cash, bank accounts, household goods like your furniture, cars, motorcycles, guns, computers, appliances, collections like a doll collection or baseball card collection, interests in insurance policies, IRAs, ERISA accounts, pension or profit-sharing plans, stocks, bonds, interests in corporations, partnerships, accounts receivables, and investments of any kind, as well as things like security deposits to which you have an entitlement, and even the proceeds of a personal injury claim that you may have that you've not yet received.
This is true even if you never filed a lawsuit. So if you got into an accident and filed bankruptcy before you received the settlement, it's likely the settlement will be taken by the trustee and distributed to your creditors. It is important that you list everything. Failure to list all of your assets may be considered fraud and could land you in jail, and that is no exaggeration. Trust me, oops, I forgot I own that old clunker in the yard will not keep you out of jail.
List everything. An important point to remember is that in many, if not most states, cash is not a protected asset. If you own a bank account at the time you filed your bankruptcy case, any funds in the bank account on the day you filed may be seized by the trustee and distributed to your creditors.
There's sometimes wildcard exemptions, which basically protect a certain dollar amount worth of property regardless of what the property is, even cash. But the following assets are typically not protected and may be seized and liquidated to pay your creditors. Consult your attorney to be certain.
Now, let's talk about Schedule C exemptions. Exemptions refers to what property a person gets to keep that may not be seized by creditors. Exemptions apply whether someone is in a bankruptcy or not. There are both federal and state exemptions. Most states do not allow the federal exemptions, just the state exemptions. Those that allow both require a bankruptcy filer to choose one or the other, either the state exemptions or the federal bankruptcy exemptions. You cannot mix and match. For some people, the state exemptions protect more of the type of property that a debtor in bankruptcy may have. For others, the federal exemptions may be more helpful. There is no across-the-board general rule of thumb. Look at what you own and see what the exemptions allow you to keep. Here's an example of how an exemption works. In Nevada, vehicles are exempt up to $15,000. So if you owned a car that was completely paid off and worth $10,000, the car would be totally exempt, meaning the bankruptcy trustee would not take it.
But if the car was worth $20,000 and was completely paid off, then this would be $5,000 more than the state exemption allows, and the trustee would probably seize the car and auction the vehicle to pay the $5,000 difference to the creditors.
Personal property is valued at garage sale, not at replacement value. For example, a couch you paid $1,000 for may only have a value on the bankruptcy schedules of $100. It is the amount that a reasonable person would pay for the property in its current condition, not new. So don't overvalue your stuff when listing your assets.
But don't undervalue your stuff either. You do that and you risk attracting the attention of the trustee